Well, welcome. Thank you so much for attending my webinar on advanced estate planning. I know how busy life is and I know how precious your time is, so it really is an honor to me that you're giving up about 45 minutes of your time to be with me and learn more about estate planning. I ask that during this presentation, you just jot down any questions you might have. And if you want me to answer those, feel free to send an email to myself, my client services director, or to info@bromlowlaw.com. I'm happy to answer your questions. If you're ready to schedule a consultation, we can do that as well. And there's always the option of a 15-minute consultation to get to know me better before you're ready to move forward. But at any rate, I'm here to answer your questions that come out of this presentation, so please feel free to reach out. I'm Laura Bromlow, and I'm an estate planning attorney with a certification in elder law through the National Elder Law Foundation. I've been practicing estate planning and elder law since 2012, although I've been practicing law since 1997. I'm actively licensed in Texas and California. So today, during my presentation, I'm going to be focusing on Texas law. I currently live in Texas and my practice is out of Texas, although I still serve California clients and remain actively licensed in that state. A lot of the concepts today may focus on Texas law, but a lot of the concepts are either federal or general in nature. So you just want to make sure you can probably get a lot of good general information from this webinar. But if you're in a state besides California or Texas specifically where I am, you are going to want to check with a professional, hopefully an estate planning attorney who solely focuses on the area of estate planning in your state, to make sure that these concepts relate to you and how they relate and how they're kind of slightly different than maybe what I'm presenting today. I'd like to tell you a little bit about my law firm, Bromlow Law. I started Bromlow Law in 2012. I'm sorry, in 2021 here in Texas because of my passion for serving families. I knew that there was a better way than how I had been helping clients through working at various firms. I knew that there was a better way to serve clients, and I wanted to do that and bring that into Bromlow Law. And so we serve clients, families, actually, in a very holistic way. We help many families of various means, so you don't have to have a certain amount of money, but we do in particular help wealthy families and families with small businesses. So to that end, Bromlow Law is really striving to be to give you personalized attention and bringing that to your unique situation. We're going to make sure that we create a plan that serves your particular circumstances. We're going to bring our expertise and experience to the table. You're going to bring your expertise of your knowledge of your family and your circumstances to the table. And together, we're going to put together a plan that addresses all of your concerns, reflects your values, and holds your family unit together. We're helping families all over avoid conflict and court. We practice in these areas. These are the sole areas that I practice in, or that anybody at my firm currently practices in. So we do estate planning. We help families put together plans so that your loved ones can stay out of conflict and out of court. Communication is key here, so we're really big on communication. We do advanced estate planning. If you need estate and gift tax planning, we're here for you and we can help you with that. We also do some asset protection. When people are concerned about asset protection for whatever reason, whether it's they have a high-risk job, they own a high-risk business, they have teenagers at home, we can help with that. Or maybe it's a long-term care issues that they're facing. We can help with that asset protection. We also handle estate administration, whether that's the probating of a will, or maybe it's an intestate proceeding. So somebody died without a will and we need to do heirship proceeding. we can help with that. And we also handle trust administration. So when someone passes away, we can help make sure that that person's assets get passed down to the right people. Now, today we're really going to be focusing on the advanced estate planning. So if you have not yet seen our video basics of estate planning, I would encourage you to go ahead and sign up for that webinar. If you can't find where to sign up for that, you can look up my YouTube channel. It's just going to be, I think Bromlow Law is the YouTube channel, but you could also email us if you want us to register you for the on-demand webinar of basics of estate planning. We'd be happy to register you for that and get that sent your way. So today we're going to spend about 45 minutes covering these topics. We're going to talk about tax considerations that you need to think about when you're doing your estate planning. We're going to talk about some strategies that you can use for those particular tax considerations. We're going to talk about asset protection and what it is, what it means. So I'll get a lot of calls from people about asset protection and they don't necessarily know what it is. So we're going to talk about that. We're going to talk about strategies for asset protection. Now, what I want you to know is that when we cover these things, I'm really focusing on educating you to identify the issue so that you know you need to get help from your professional in employing strategies. So I'm not going to spend as much time on the particular strategies because that's my job and that's your professional's job. But it really is important for you to really understand, the considerations, the tax considerations, understand what asset protection is and maybe what it entails to get asset protection so that you can identify that, hey, that's something that I need to follow through with my professional on. So we're going to start with tax considerations. In estate planning, the taxes that we're mostly concerned with are estate taxes, gift taxes, generation skipping taxes, income and capital gains taxes, and property taxes. In this presentation, I'm going to be focusing on estate and gift taxes as well as capital gains. So let's get started. Estate and gift tax. Okay, the federal government has estate and gift tax laws, and every single state has its own laws pertaining to estate and gift tax. Here in Texas and in California, there's no estate and gift tax. So my discussion today is going to be limited to the federal laws that are in place. Again, if you live in a state other than California and Texas, you are going to want to find out if your state also has laws about estate and gift tax on top of the federal. But today we're focusing on the federal law. The current law came into effect in 2017. It's called the Tax Cuts and Jobs Act. The current federal law and on estate governing estate and gift taxes puts the gift and estate tax exclusion amount at $12.92 million per person. So that means that each person can die with up to $12.92 million without their estate being taxed. Anything above the $12.92 million is going to be taxed at a 40% rate. This exemption amount is a unified credit amount. That means that the lifetime gifts plus your estate at your death are included in calculating the tax. So let's give an example. If you give away $5 million over your lifetime, you could die and pass on another $7.92 million and still have no estate or gift tax consequences. The IRS keeps track of this by making it mandatory that when you give a gift over a certain amount, over $17,000 in 2023, if you give a gift over that amount, and we'll talk about that further in a minute, then you have to report it. It's mandatory. It's required by under the Internal Revenue Code that you give notice to the IRS when you've given a gift away over, in 2023, $17,000 or whatever it is at the current time. So basically, the IRS is keeping a ledger of everything you've given away over your lifetime so that they can calculate that plus what you're passing on at your death to make sure it doesn't go over the $12.92 million, okay? There's a few things to know about the law as it currently exists. Number one, when you're married, you essentially double the estate and gift tax exemption amount because of something called portability. When one spouse dies, the surviving spouse can port to him or herself the remaining amount of the deceased spouse's exemption, which increases the surviving spouse's exemption amount by that much. So let's give an example. If the first spouse dies owning $5 million, that leaves that spouse with excess exemption amount of 7.92 million. Well, the surviving spouse can port the 7.92 remaining in the deceased spouse's exemption to him or herself, and that gives the surviving spouse the 12.92 that he or she started with, plus the 7.92 million that the deceased spouse left on the table. And the surviving spouse is going to have over $18 million to pass on when he or she dies. Number two, there's also something called an unlimited marital deduction. That simply means that spouses can give each other money with no tax consequences. It doesn't go against their lifetime gifting exemption, and they don't have to report it. So there's no limit to how much the spouses can give each other without reporting it or having any tax consequence. And number three, finally, there's an annual exclusion amount over and above the regular lifetime gifting exemption. And so that's kind of what I was referring to when I said 17,000. In 2023, you can give away $17,000 to as many different people as you want every year with no tax consequence and no need to report it to the IRS. So if you have 10 grandchildren, you can essentially give away $170,000, one $17,000 gift to each grandchild, and no tax consequences there. Okay. Even better, if you're married, your spouse can also do the same thing. And so between the two of you, you've just given away not $170,000 in 1 year free of taxes, but $340,000 free of taxes been given away that year. Now in 2026, this law, the current law, is going to sunset, meaning things are going to go back to the way they were in 2017 before this law was brought into effect. So that means that the gift and estate tax exemption is going to go back down to $5 million indexed for inflation. That's where it was at the time that the current law came into play. $5 million indexed for inflation is what you will be allowed over your lifetime, coupled with at death, to give away without taxes. We're estimating that that $5 million plus inflation will be around 7 million, maybe 8 million per person in 2026. That's just a rough guess, so don't hold me to it. But we'll use that kind of as a place to give examples, a starting place to give examples from. This is still going to be a unified credit, and all the other rules that we talked about, including portability, unlimited marital deduction, the 40% tax rate, all of those things are going to remain the same. It's just that the amount you're allowed to give away either during your life or at death has changed significantly to nearly half of what it currently is. The annual exclusion, let me just say, tends to change every year. So you need to look at that every year and see what that is. So let's talk about whether or not you should care about these rules. I mean, that exemption amount seems fairly high. So does this affect you? You may be thinking it doesn't affect you right now because you don't have almost $13 million, and between you and your spouse, you don't have almost $26 million. So it probably doesn't affect you currently. A lot of my clients are in that boat, but there's some things to think about if you don't have a current taxable estate. So let's talk about that. Who should consider tax planning? I would say that if you already have a taxable estate, obviously you need to do some tax planning. In fact, I would say that you're delinquent in doing so if you haven't already thought about it. But hopefully your estate planning attorney has thought about it and placed in provisions in your plan that would take into consideration, if you did die and how that would help. So hopefully you've got an estate planning attorney that's on top of it. So for example, even in my smaller estates, I put in some contingency language that would help with taxable estates in case the law changes and my clients never get around to coming back to me. So there are certain things that can be put in your plans that can help with this. So hopefully you have that. But what if you don't have an estate tax issue now in 2023? So you don't have that high amount of money. There is a bigger question that comes in. There are a lot of people out there waiting for 2025 to do anything about this. They're sitting there, with more than $5 million, but less than 13 million. And so they're thinking, well, it's going to go down in 2026. I don't need to, worry about this until then. So they're kind of waiting until fall of 2025. They're going to say, in fall of 2025, I'm going to do some things about this, either because I have a taxable estate now and I want to make sure I do something before it reverts down even further, or I'll have a taxable estate when it reverts. So I'll just wait until the fall of 2025 to do something about it. That way, if I die in 2026, it's done. Well, first problem with this is that if everyone waits until the fall of 2025, estate planning attorneys all over the place are going to start being bombarded with this work, and they're probably not going to get yours done by 2026 because they're going to have a long line of clients doing the same thing. The second problem with this is that you don't get to take advantage of the current situation. So how about this? How about you take advantage of the current high exemption amount? So if you have a large enough estate to do so, you could give away over $5 million indexed for inflation amount now. So let's say, call it 7 million, and it's still going to be exempt in 2026 or after when you die, if the then current exemption amount is only $5 million indexed. So in other words, let's try to clarify this. So in other words, if your estate is large enough, you could give away $12.92 million now. And then if you died after 2026 and the exemption has gone back down to, let's call it $7 million, your estate's not going to be taxed because you gave it all away during the now high exemption rate while that was in place. You gave it away during your lifetime. And so they're not going to go then and say, well, you gave more than the 7 million. No. So the moral of the story is, don't wait. If you've got that situation, go ahead and have the conversation with your professionals. So I would say that you should be having this conversation with your professionals if you have anything over $5 million in an estate right now. Just make sure that you have the conversation so you've taken into consideration everything you need to with your professional, because at 40%, at a 40% tax rate, the estate and gift tax is no joke. So you want to make sure that you avoid it if you can. Let's talk about capital gains tax, which is another tax. It falls under income tax, so that's why this is presented the way it is. Capital gains tax is the tax that you pay on the difference between the basis or the price at which you purchased or acquired it, the asset, the difference between that and the sales price when you get rid of the asset. So, for an example, if you purchase real property, we're not going to talk about your homestead right now. We're going to talk about some other piece of real property. Maybe it's a vacation home. Let's say you purchased that for $500,000 in 2020, and then in 2030, you sell it for $1 million. There is a gain of $500,000, and that's called capital gains. And that's the difference between the purchase price of 500 and the sales price of $1 million. And so you're going to be taxed on that gain of $500,000. In estate planning, we have a major number one mistake that people make with regards to this tax. Sometimes people think it's going to be easier for me to give up my home or some other asset to my children while I'm alive. Let's just do it now so they don't have to worry about going to court and doing a probate when I die. And we'll get rid of it. We'll give it to them now and they can take advantage of it now. They can have it. And then we don't have to worry about stuff when I die. This is a big mistake. So let me give you a very clear example. Let's say parents purchase a home in 1980. Not uncommon, not a ridiculous thought, right? They purchased it in 1980 for $100,000. Let's say that the parent now gives the child the home before they die. The child acquires the house. Let's say they give the home to the child now in 2023, and they had purchased it at $100,000. They give the child this house. The child is taking it with a basis of $100,000 because they take on the grantor's basis. If the child then turns around and sells the home later for, let's say, $800,000, that child now has a gain of $700,000 to pay taxes on. Compare that with if the child would inherit the property after mom and dad dies. So let's say mom and dad die, they leave the house to children upon their death. Now the children take it with a step up in basis. So they acquire the house at its current fair market value, $800,000. And when they turn around and sell it for $800,000, there's no capital gains that they pay. So they totally avoid the capital gains tax. And we'll refer to that as a step up in basis, that you want to get that step up in basis. So whatever your planning is, that's what we're thinking of. We want to get the step up. Let's talk about tax strategies. Now, I just talked to you about the capital gains tax strategy of not leaving that step up behind. We want to make sure we get that step up. But so we're going to focus in on some estate tax strategies, okay? There's two main categories of strategies for estate taxes. And then there's some additional considerations that I want to make sure that you understand. First, you can start a gifting plan now while the exclusion amount is high and before it's reduced in 2026 so that you can take full advantage of the higher exemption amount. In other words, let's lock in that higher exemption amount. The gifting strategies that we can look to are the spousal lifetime asset trusts, IDGITs, which I'll explain, and gifting trust, which are IDGITs and gifting trust. We can kind of think of them together. Let's start with the spousal lifetime asset trust. These work well. You have to be married, obviously, spousal. In Texas, what we would do is we would create separate property among the spouses so that each spouse has their own separate property that they can gift to the other spouse. And so here, let's remember what we've already learned, which is the unlimited spousal exclusion amount. Remember, we can give to our spouse without tax consequence an unlimited amount. So this is the beauty, right? We're going to gift our separate property, but we're going to gift it in trust. And so we get that exclusion, the unlimited marital exclusion, but at the same time, we're putting it in an irrevocable trust so that when the spouse dies, it's not part of the spouse's estate either. So this is a very beautiful thing that we can set up for estate tax purposes. For the IDGIT and the gifting trust, what we're talking about here is creating an irrevocable trust and taking our assets and putting it into this irrevocable, meaning you can't change it, you have less control over it, for the benefit of our children. Now, it stays out of the children's taxable estate when they pass on. But the thing to keep in mind here is that when you're taking your money and gifting it into there, it does count against the gifting the gifting rules. So you have to keep that in mind. So you could still use your annual exclusion amount to gift into it, or just keep in mind how much you're gifting into it so that you're not going over your exemption amount. But this is a useful tool as well. And you'll see that this can kind of be a useful tool for asset protection as well. And we'll talk about that in a bit. This strategy, these gifting strategies are to get it out of your estate through gifting without having a consequence on your estate, or very strategically. Okay. So there's a lot of decisions that go into this. Number one, how we design the trust, but also what assets we're going to put into those trusts. So it's not going to be a quick conversation. This is going to be something you're going to need to talk to your professionals about. Another thing within the gifting strategies would be charitable giving. So you can do some charitable giving strategies if you are charitably inclined, and that's something that you should keep in mind. Hey, I really want to benefit my church. And so, hey, professional, what can I do strategy wise to avoid estate taxes if I want to do something with charities? Good to keep that in mind. Now, the other strategy is we're not going to avoid the estate tax. We know we're going to have an estate tax. Maybe we employ some of the gifting strategies to reduce our estate tax, but we know we're still going to be left with some sort of estate tax. And so we're going to do something to put in place some plan that would end up paying the estate tax, so that at least my kids don't feel the burden, the 40% tax rate burden when they inherit the money. This is going to be usually through something called an ILIT, or an irrevocable life insurance trust. And how that works is that we create the irrevocable trust. We purchase through the trust. We're going to use our annual exclusion to fund money into this trust. So we're going to gift in $17,000. And then with that money, or more, with that money, we're going to purchase life insurance policies that are owned by that trust, so that when you die, and they're going to be on your life, and so that when you die, there's that money from the life insurance policy that goes to pay off the estate tax that will be due. Now, some other things to keep in mind besides these two strategies when you're doing estate tax planning is that you always want to be using your annual exclusion if you have a taxable estate. So somehow you just want to check what the current rate is every year, and you're going to want your spouse to do the same. Now, you can use educational accounts to give away big chunks of money. So if you've got the 10 grandkids, you can actually front load a 529 plan with 5 years of gifts. So that means $85,000 to each grandchild. So remember the 10 grandchildren we had? That means that you could set up 529 plans for each of the 10 grandchildren, gift into each of those $85,000. Now, this is going to be a great thing to do before 2026 so that you can get assets out of your estate and make sure you're taking advantage of that higher exclusion amount. Now, once you do the $85,000 into a 529 plan, or whatever amount of years you want to front load the 529 for, you just have to keep in mind that for grandchild A that you just contributed $85,000 to their 529 plan, now you can't go and next year give them their $17,000 gift. That takes that off the table for 5 years as to that one child. So keep that in mind. So that was it about estate tax planning. So now we're going to move on to asset protection. So what even is it? What is asset protection? People often call me, and say, hey, I want to set up some asset protection for my property. Can't I set up a revocable living trust and that'll protect my assets? No. A revocable living trust does not protect assets. It is simply a probate avoidance tool. It does not protect assets from creditors. And so let's talk about what asset protection is. And through this discussion, you're going to see why you may or may not want to enter into asset protection. Asset protection is planning to protect your assets from creditor claims within the limits of the law. It is also getting creditors to, getting creditors to see the light and want to settle with you more quickly than they otherwise would. So you're making things, distasteful for creditors to seek a judgment against you, or they've already gotten a judgment and we're seeking to get them to settle quicker than they otherwise would, and in a manner that would be the best outcome for you. So we want to force creditor settlement. There's 3 levels of asset protection. And so I'm going to talk about 1 and 3 here. I'm going to be talking about 2 of the ways you can approach asset protection. We're going to discuss insurance and exemption planning, and we're going to talk about creating trusts or legal entities to create asset protection. So let's first start with insurance and exemption planning. Every state has its own rules about what assets are exempt, or in other words, not reachable by judgment creditors. Texas happens to be a debtor-friendly state. Texas wants to protect its debtors. Basically, we don't want people living on the state's payroll, right? So we don't want to be having to cough up a lot of money. So we want to protect debtors as much as possible so they don't end up destitute and living on state money. So our exemption laws are pretty good for asset protection. An exempt asset is one that the state has determined is unavailable to creditors who have received a judgment against you. So you already have some asset protection built in when you own certain exempt assets. So we'll talk about what those exempt assets are in just a minute. Insurance is also an important part of asset protection, and I would say a first line of defense after the exempt assets. And we'll talk about, insurance and its limits in a bit. Exempt assets in Texas includes many things. As I said, we're a debtor-friendly state. All these things that I've listed are exempt assets. That means if you get into trouble with a creditor, they get a judgment against you, they're not going to be able to recover against your homestead, personal property, 529 plans, life insurance policy, annuities, and qualified retirement plans. Now, about the homestead, there are certain limitations on acreage, but I would say that you have to have a pretty gigantic piece of property for it to exceed homestead limits. So there's specific laws about that. But if you have a very sizable homestead, you may want to talk to your professional about, hey, how much of this is protected and how does that affect it? Because I've got a lot of acreage, but you have to have a pretty sizable piece of land before that's affected at all. So most of us, we live in, a neighborhood, or we live on a nice piece of land, but are going to be covered completely by our homestead. Exemption amount is going to be fine for what we have. Personal property is going to cover up to, I think it's $62,000 or $65,000 amount of personal property. 529 plans, life insurance. Okay. What I want to say about qualified retirement plans is that it covers also inherited IRAs. So if you received an inheritance of your parents and you have an inherited IRA from them, this is also an exempt asset in Texas. So that's good news for everybody. One thing you want to keep in mind when we talk about asset protection is fraudulent transfers. And so I just want to kind of give this a plug right away, a shout up front so that you've got it in the back of your mind. When we talk about asset protection for those assets above and beyond the exempt assets that we just went through, a key idea to keep in mind is this fraudulent transfers. The key here is to make sure you're planning ahead. So if you have a high risk job, or you have high risk assets, or you have teenagers, you will want to do your asset protection planning well in advance of ever having a claim filed against you. If the timing of your planning, whatever you end up doing to protect your assets, If that's too close to the time of the claim made against you, then the transfers are going to be considered fraudulent and your planning will fail. So you must plan ahead. Here's some key ideas in asset protection. So first of all, as I just said, plan before a claim occurs, plan well in advance. Otherwise you have a fraudulent transfer on your hands. We're going to create obstacles. So you're going to make your plan multi-layered by creating one or more business entities, maybe LLCs, along with trusts. And the intent here is to tire out the potential creditor and make them more likely to settle if they do get a judgment against you. But sometimes it even dissuades them from filing suit because they see that it's too complicated and you don't have enough access to these things. Number 3, don't make it more complicated than necessary. So you're going to want to make it simple. You need to be able to explain your plan. If you can't, it's not going to be a good one. Get insurance, but don't rely on it. So here's where I said we're going to talk about the limits of insurance. So yes, it's a first line of defense, really important to get the right policies in place. Really important to get the right broker that you can talk to about insurance, who can look at your situation. You tell them all your assets and they can look at your situation and go, oh, you know, I see a gap here that could be filled. Really important to get a good broker, not a run-of-the-mill, you know, person who does insurance, but a good broker who can look at your overall plan, maybe along with your financial advisor and your estate planning attorney, and say, you know, I think I see these places where this person could use insurance. Okay. But having said that, after you've gotten the insurance in place, you know that a lot of companies, you've probably heard horror stories, don't like to pay. Some companies don't like to pay when you submit a claim. So that's one thing, one hurdle. The other one is the limits that you chose may not be enough to cover the lawsuit. So there's those things. So it's a good first line of defense. You want to use business entities. So there's automatic protection that comes with business entities. However, just creating an entity for namesake only does not do a whole lot. You've got to make sure you're running the business as a business to bring in the asset protection. So if you have an LLC, the creditor can only get what's available to the member of the LLC. So if the member doesn't have any say about distributions, let's say there's more than one member in this LLC. I'm a member, but the rules of my LLC that we've set forth say that I don't have any right to demand distribution. If somebody sues me, my creditor is going to stand in my shoes. And so if I can't demand distribution, neither can my creditor. And so maybe the member who does decide distributions sees that I have a judgment against me and they're like, you know what? I'm not giving Laura any distributions right now. And in fact, all she's going to get is a tax liability because she's got phantom income now that, you know, because the LLC made money, even though I'm not going to distribute it, Laura's share to her, she still owes taxes on it. And so the creditor is not going to get a distribution. Now the creditor just has a liability of taxes. They don't want that. So they're probably going to want to go away. The other thing, number 6, use trust. Trusts have to be structured properly, and we can use them in conjunction with the business entity. But what we want to keep in mind is that when you create a business entity and when you create a trust, you are creating additional tax consequences. So you always have to weigh, how much do I really need asset protection? Is it worth this additional tax liability? Let me make sure I understand the additional tax liability with my estate planning attorney and my CPA. They will tell me what my additional tax liability is and whether this is prudent for me to invest in this kind of planning, given my risk for, you know, creditors. The last thing that I want to point out is past asset protection to the next generation. Now, this is easy to do, something that you definitely, if you have enough assets that you're passing on to your children or your grandchildren or whoever, you can give them the gift of asset protection that they cannot give themselves. Along with this asset protection is divorce protection. So you're going to be giving them divorce and asset protection. You're putting it in a lifetime trust for their benefit. They may or may not be able to manage it. And we'll talk about that in a private consultation about, how we want to set that up. And that will depend a lot on how much control or versus asset protection you want the child to have. So I like to think of asset protection as a spectrum. On one end of the spectrum, we have absolute control over the asset. I own it. I'm the only one that gets to say what gets done with that asset. I have total control over that asset. And so guess what? Because I have total control, total ownership, and everything belongs to me, I have no asset protection, absolutely none, because guess what? The creditor steps into my shoes and they can get what I get, total control, total ownership, right? To pay off the judgment. On the other end of the spectrum, you have no control, you have no ownership. And so when I want to do something with that asset, I don't get to say so. And guess what? My creditor also, when they step into my shoes, can't get to that asset. Well, this end of the spectrum will be like, you don't own it at all, right? Somebody else does. It's somebody else's asset. So you're never going to get complete, total protection. You're never going to get this end. You're going to end up somewhere between here and here on the spectrum. And we can tweak the documents. We can use tools to get, less protection, just a little bit of protection, a little bit more, a little bit more, a little bit more, all the way until we've almost got full protection, but we can never have absolute 100%. Okay. So we're going to end up somewhere on that spectrum. Same thing with what I was just talking about with this lifetime trust that we can leave to our children. That's what started me on this segue. But, when we leave assets for the benefit of someone else, we can give them almost full protection. They're not going to have much control, or we can give them a lot of control, but a little, very little asset protection, or we can give them somewhere in the middle, anywhere. Let's take a look at some asset protection strategies. We've talked about business entities and trust, and so we're going to look at those just a little bit closer. Business entities come in several forms. So you're probably familiar with something called a sole proprietorship. This provides absolutely no asset protection. It's the simplest way to do business. It's just you doing business. But because it's just you, if you end up with a creditor who has sued you and gotten a judgment against you, guess what? They're standing in your shoes and they can recover against you. Remember, they can't take your home or any of those other exempt assets that we talked about, but they could take all of your business-related assets to pay off the judgment against you. In order to create some protection, we have to create some separation, and some separation from control or ownership. I like to think of asset protection as that spectrum that we just talked about. So the more control you have, the less protection from creditors. The less control you have, the more protection. In fact, we talked about if you give your assets completely away to someone else, you have total creditor protection, right? So the basic concept follows through these two strategies. In the LLC, you will still have some control. So if you're a sole member LLC, you're likely going to have a lot of control. So guess what? The liability protection that you can get from a single member LLC is going to be limited. It's going to be limited liability protection. But we can beef it up. There's lots of ways we can beef it up. You can add more members. You could introduce a second LLC, or we can add a trust to kind of, make it multi-layered, that it owns a portion of the LLC, even if you're, the only trustee of the trust, or there's other ways we can do it. So we can use tools together to kind of create a little bit more layers to avoid creditors wanting to go after you because it's too convoluted for them. A corporation is another entity that creates separation. You have a similar analysis as with the LLC. So if you're going to want more than one shareholder, or, create some layers. Finally, you can create a family limited partnership, an FLP. These can be a beautiful thing for asset protection and also for family business succession planning. So we can create decision-making roles, non-decision-making roles, and we can have everybody benefit from the profits of the business, but, some of them making less decisions than others. Distributions can be discretionary depending on the amount of the asset protection we want to provide certain individuals, or on how much control we want to give individuals. In addition to business entities, we can also think about doing trust to do those multi-layers. So we can still have the spousal trusts that are similar to what we've already talked about with the tax planning. We can still do gifting trust, and we always have that lifetime trust when we pass on our assets to the next generation. So for the spousal trust here, what we're doing is we're still creating those separate trusts, but we're going to design them slightly different for the asset protection side of things. So we're going to look at who's in control of making the distributions from the trust. That's going to, give less control to the spouse, creating them more asset protection on that spectrum, remember? So we've covered a lot of information in this webinar. I've talked, hopefully what I've done is highlighted the issues that you may want to address with your estate planning attorney and your other professionals. That was really the goal. We've given you some strategies and ideas of what some of the strategies are, but your professional will be able to go into more detail about those. I want you to know that if you've got a concern with estate planning, whether you have these issues that we talked about today, or you've got another issue that you want to make sure is covered in your estate plan, if you're in California or Texas, please reach out to me. I'd be happy to help you. We're always here to help. If you're in another state and you need a referral, let me know. I can help you find someone. If you are interested in working with Bromlow Law, I just wanted you to see how our process works. We start with a questionnaire, which is very lengthy. It's going to give me a lot of information about your values and your financial situation and your family situation. I'm going to use that to prepare for the Love and Legacy consultation, which is a consultation where we'll meet either in person or by Zoom, and it'll last up to 2 hours. And I will get to know you. You'll get to know me. I can answer any questions you have, and we can go right into the designing of your estate plan at that meeting, and make sure that all of your concerns are met. A week after you hire me to do your estate plan, I'm going to send you a confirmation of important and missing information. And this is going to be a document that just confirms what we talked about in that Love and Legacy consultation. Make sure that I've got everybody's name spelled right, I've got their addresses correct, but also very important about this is that I understood what you wanted done with your estate plan. You'll return that to me. And once you return that to me, a couple weeks after you return it to me, we'll have a draft review. A draft review is always going to be by Zoom, preferably. There are some people that I'll meet in person because they don't do Zoom well, but I like to do it by Zoom. I pull up the document on the screen, just like you're seeing my PowerPoint right now, and we go through the document together, and I explain to you what you're going to be signing. There's several purposes for this meeting. Number one is to reinforce to you how your plan works. You're hearing it again. You heard it in the Love and Legacy consultation. You may have heard it from a video that I've recorded, and now you're going to hear it again in the draft review. The more times you hear how your plan works, the better able you will be to understand it and convey it to your loved ones so that they're not totally lost when the time comes. So we're going to do that draft review, make you sure you understand your plan. Make sure you understand what each of the documents in your estate plan does and how you would use them, or how your loved ones would use them, and to make sure you understand what you're going to be signing. Okay, so that's what we use the draft review for. Then a couple of days after the draft review, you're going to have a signing. If you're local to me in Texas, you're going to come into the office, and my client services director is going to do the signing with you. She's going to notarize everything. If you are remote in Texas or in California, I will send out a notary to you to do the signing. And then my client services director is going to reach out after the signing to set up another meeting with me or my staff to coordinate your assets with the trust. And so what this meeting is usually a Zoom call, again, where we pull up your asset spreadsheet that we've talked about several times already to this point in the process. And we go through with each asset, we tell you what you need to do in order to coordinate it with your estate plan. This is important to do whether you have a will-based plan or a trust-based plan. You just want to know what's going to happen to each one of your assets if you become incapacitated or when you die. Then we always offer a family meeting. This is an opportunity for me or the attorney that's working on your case to meet with the people that you identified as important people in your plan, whoever you want to, really, but usually it's going to be your executor or your successor trustees and your agents under your power of attorney, or your agents under your healthcare document, maybe your kids if they're not those people. But this family meeting is a time for them to not only meet me, so they know they've seen my face, they remember to call me if they need something happens to you. But it's also a time for them to kind of understand what their role in your plan would be. So some of the family not going to have a role, and they need to hear that. And some of the family is going to have a role, and they need to hear that. And so this family meeting is just a really great opportunity to get everybody on the same page. It says to your family, hey, this is my estate, this is my life that I've planned, and this is the plan I put in place, and I want you to abide by it. It goes a long way to avoiding conflict down the line, or that's my hope. I also always offer a legacy interview. This is an opportunity for you to have a recorded session with someone asking you pointed questions that you agreed to be asked ahead of time, or an opportunity for you to tell a story. So we'll just record the session for you, and we save it to a flash drive. You'll get the flash drive with all your other documents on it, but that will be for the family to see at a later date when you've passed away. And so it's your gift, your true legacy, your advice that you want to tell them, the values that you want to share with them, or stories that you want to tell them. And then finally, we'd like to have a lifetime relationship with our clients. And so we don't like it to just end at the signing table, right? We want to have an ongoing relationship with you. So I send out newsletters. I will check in periodically. I will hold client events. We're getting ready to start holding some of those client events for clients. We've only been in practice for 2.5 years with this firm, so it's about time to start having some of those events. And then I'll do some education for clients. I'll have one coming up, I believe it's in September, for, trustee school, but you'll look out for trustee school, which will be available to my clients, or other types of educational events for clients. So that's how I like to maintain a lifetime relationship. Just one last thing I'd like to tell you about this is that if you ever have a legal need, if you're a client of mine, I want to be the first name that you think of. I have connections with other attorneys. I know how to find the right attorney for my clients, and I would love to help you with that. So keep that in mind. Love and Legacy consultation. I just wanted to make a note about what that is. Remember, it's about a 2-hour meeting. It's going to go a long way to getting you more financially organized so that you know what your assets are, keeps them out of unclaimed property. During this meeting, you're going to make informed and empowered choices, choosing the right plan for you and your family. Our prices for these plans range anywhere from about $3,000 to $8,000 or more, with most people falling in the range of, I would say, between $4,000 and $6,000. But all fees are going to be flat fee, because I want to make sure that you don't have any surprises about your fees, that you know ahead of time, you know up front how much you're going to owe. So I'm very clear on that. And then the other reason I do flat fees is because I want to make sure that my clients feel comfortable calling me or emailing me, and that they're not going to get billed for every minute of my time that they take. So that's why I avoid hourly fees when I can. You're going to know after this meeting for certainty that your family is properly guided throughout your life. In case of, your incapacity or death, you're going to know that they're taken care of, and you've gone a long way to avoiding conflict within the family unit. Now, for attending this webinar today, we are offering a gift worth $1,100. First of all is a free Love and Legacy consultation. That's an $800 value. My hourly rate is $400 an hour. I give you 2 hours of my time, $800. I will also additionally take off $300 from your estate planning if you sign up within 3 days of seeing this video. So in order to redeem the gift, you're going to need to call or email. You can call the office, of course, or you can email Dina at Bromlow Law. You could also email me if you like, but Dina's might be quicker at getting back to you. She's also the one that handles my scheduling, so you would end up talking to her anyway. And info at Bromlow Law. The next steps would be to email myself or Dina and claim your gift here. So just keep in mind, planning is bringing the future into the present so that you can do something about it now. We want you to take this step to do something about your future now while you're seeing clearly and you're in a good place to do so. So if you'd like to get in touch with us, here's our address, here's our phone number, and you can always email us. In place of info, you can put Dina or Laura if you want to get a hold of us directly. But I want to thank you so much for attending today's webinar, and love to hear from you. Take care, and make sure you take care of that family. Bye-bye.